This is Bentley Tolk for the ERISA Litigation channel. After a brief hiatus, I am back, and I work at Parr Brown, Lovelace in Salt Lake City. My practice focuses on ERISA litigation defense. What I'd like to do is to talk a little bit about an important Supreme Court decision that talks about SPDs and misrepresentations in plan reformation. That case is the CIGNA Corp. Versus Amara case, which is May 16, 2011. The facts briefly are the case are that in 1998, CIGNA changed its pension plan. The old plan provided a defined benefit through an annuity that was based on pre-retirement salary as well as length of service. The new plan, in general, provided a lump sum cash balance that was determined from a defined yearly contribution from CIGNA that would be increased through compound interest. The new plan converted already earned benefits from the old plan into an initial amount that would be in the employee's cash balance account. Now, approximately 25,000 plan beneficiaries in a class action challenged this adoption of CIGNA's new pension plan and claimed that there was a lack of proper notice about the changes and also about how the benefits were less generous under the new plan. The district court held that CIGNA had violated its obligations under ERISA, and the district court held that CIGNA's notice deficiencies had caused likely harm to the employees. The district court reformed the new plan and ordered that CIGNA pay benefits accordingly under ERISA Section 502A1B. The Supreme Court, in taking the case, agreed to decide whether a, quote, likely harm, end quote, standard is correct in determining that CIGNA's notice violations caused enough injury to employees or sufficient injury to warrant legal relief, and whether ERISA Section 502A1B authorizes the type of relief that the district court awarded. Now, the Supreme Court held that Section 502A1B doesn't authorize entry of the district court's provided relief, but that Section 502A3 does authorize forms of relief similar to those awarded by the district court. According to the Supreme Court, the applicable standard of harm will depend upon the equitable theory under which the district court provides relief. Now, the district court, going back, had found that CIGNA had incompletely and misleadingly described its new plan in its initial descriptions. First of all, what the district court said was that CIGNA didn't tell its employees that the new plan actually saved CIGNA money, and that it actually made many employees worse off through taking away an early retirement right and adjusting CIGNA's initial deposit downward and shifting the risk of a fall in interest rates from CIGNA to its employees. And then secondly, the district court said that CIGNA had intentionally misled its employees. According to the district court, CIGNA's misrepresentations or representations violated, first of all, ERISA Section 204H, which at the time didn't allow a pension plan amendment that would provide a significant reduction in future benefit accrual rate, the future benefit accrual rate, unless the administrator sent written notice. And then also the district court said that the representations violated Sections 102A and 104B, which require an SPD and summaries of material modifications written in a manner that could be understood by the average plan participant. The district court, with regard to remedies, held as follows. First of all, only employees who had been harmed by the disclosure failures could get relief, but they didn't need to show individual injury because there was a presumption of likely harm that was unrebutted. Now, the district court also said that the Second Circuit had in the past used Section 204H to invalidate plan amendments that had not been preceded by proper notice. The district court also said that that it was reforming the terms of the new plan's guarantee, actually giving participants more favorable benefits. The district court enjoined the plan to reform its records to reflect the more favorable benefits, and also that it pay benefits accordingly to already retired class members. The district court also stated that Section A1B, 502A1B, provided the legal authority for this relief. And finally, the district court didn't need to decide, it said, whether Section 502A3 also provided authority for this relief, because Section A1B already provided for it, and the Supreme Court had curtailed relief under Section A3 in Sereboff, Great West, and also the Mertens case. The Court of Appeals briefly affirmed the district court's opinion for substantially the reasons that had been set out by the district court. And again, as I mentioned earlier, the Supreme Court granted CIGNA's petition to consider whether a likely harm showing is enough to allow participants to recover benefits due to faulty disclosures. The Supreme Court first noted that Section A1B, 502A1B, doesn't allow a court to alter plan terms. The Supreme Court also rejected the Solicitor General's rationale that the district court did enforce the SPD, and that the terms of the SPD are terms of the plan. According to the Supreme Court, Section 102A requires that SPDs advise of rights under the plan. Also, the plan sponsor creates the plan terms while the administrator provides summary documents. And third, the SPD language is supposed to be simple, and if it were binding, plan administrators might make the language of SPDs complex. The Supreme Court concluded that summary documents communicate with beneficiaries about the plan, but their statements don't themselves constitute the terms of the plan under Section 502A1B. And also, the district court couldn't find authority in Section A1B to reform CIGNA's plan as written. Now, with regard to Section 502A3, the Supreme Court found that relief ordered by the district court resembled traditional equitable relief and fell within the scope of the terms appropriate equitable relief in A3. The Supreme Court noted in connection with Section 502A3 that what the district court did was like reformation, which is a traditional equitable power. It was like reformation of plan terms to remedy false or misleading information. And the district court held CIGNA to what it had promised, not taking away accrued benefits, and held that CIGNA couldn't take away accrued benefits, and also that resembled estoppel, which was also a traditional equitable remedy. Thirdly, the district court's injunction to pay money owed under the reform plan to already retired beneficiaries was like a surcharge, which was also equitable relief. And that applied when the defendant was analogous, as it was in this case, to a trustee. According to the Supreme Court, any requirement of harm must come from the law of equity. For a remedy equivalent to estoppel under Section 502A3, a detrimental reliance showing must be made, according to the Supreme Court. Now, the Supreme Court also said that a detrimental reliance showing isn't always necessary for other equitable reliefs, for example, for reformation of contracts or a surcharge. And then also, according to the Supreme Court, a fiduciary can be surcharged under Section 502A3 only upon a showing of actual harm proven by a preponderance of the evidence, and that actual harm sometimes may be detrimental reliance, but it could also be the loss of a right protected under ERISA. To get relief by surcharge for violations of Sections 102A and Section 104B, according to the Supreme Court, a beneficiary must show that the violation injured him or her, but to do so, he need only show causation. Also, actual harm, according to the Supreme Court, must be shown, but a showing of detrimental reliance isn't always necessary. In summary, what the U.S. Supreme Court did was that the district court's judgment was vacated because the district court hadn't determined whether an appropriate remedy might be imposed under Section 502A3, and the district court had relied on Section 502A1B. Well, it's good to be back with the ERISA Litigation channel, and I look forward to future episodes for the ERISA Litigation channel. This is Bentley Tolk. Thank you.